application and appeal in the matter of the claimant application of BC and the Surrey County Council.
Yes, listening.
Yesterday we left off on the first way in which the judge dealt with the question of delay, and I'm now going to move on to the second fallback way in which the judge dealt with it, and that starts at paragraph 99 of the court's judgment at 157 of the core bundle. This is a question of whether the judge erred in law in the exercise of his discretion, and so it falls within the scope of paragraph 21.8 of Thornton Hall that we looked at yesterday. My Lord Justice Coulson yesterday asked me to identify when the judge identify the date starting, when he says what period he was considering in terms of an extension of time. As you'll see from paragraph 90 of the judgment, the judge identified the position of the council is that time started running from the end of 2019, and the claim wasn't brought until August 2022. And in our respectful submission, the judge proceeded on the basis of taking the local authority's position at its very highest, therefore considering the maximum period of contended delay and asking himself whether there were reasons to justify that extension of time. And you'll see at paragraph 100 of the judgment, he says in the second sentence, the judge considered that at the time of 2019, BC didn't know that the local authority had acted unlawfully, or that he could challenge the way he had been treated, and that he was only referred to legal advice and assistance, that's the last line of that paragraph, by his psychologist in 2021. Of course, we accept that whilst you don't know, it doesn't mean that time doesn't start to run. But as my Lord Justice Coulson said to my learned friend yesterday, that may well be a good reason for a court to extend time.
Maybe.
Maybe. I said maybe a reason for extension of time. BC's knowledge or lack thereof in this case was an important feature of the judge's consideration of the question of delay, particularly as I mentioned yesterday. This was a case where there had been no decision provided, not made, but provided to BC, informed to him so that he is capable of knowing what was decided in his case. And for that, I'd like to take the court to the text that he received on the 20th of September, and that's supplementary bundle 26.
I'm so sorry, I missed the page number, Ms. Liu.
Page 26 of the supplementary bundle.
Thank you.
At the bottom, the case note starts at the very bottom of 25. You'll see the date of that. It's 20th of September. And then on the top of the page, it says text to BC. And you can see what the text says. And one has to, in our respectful submission, read the text from the perspective of a 17-year-old, not from the perspective of lawyers. The text in
Sorry, I haven't quite got it.
Oh.
Text sent to BC
yes,
in the top of 26.
Yes.
Yeah.
That's the text that was sent to BC. And in our respectful submission, you have to look at that text in the context.
One on the top of 26?
Yes, there are no date on the top of 26, but the date is at the bottom of 25.
Yes, the 20th.
Yes, yeah. I thought I said that. Sorry, I didn't.
I'm sure I misheard you.
Yeah.
Sorry.
So it's yes. So 20th of September, because you recall that Ms. Rowlands took you to a decision of the 20th of September.
The way this works is it's reverse chronological order.
I think that is, although sometimes they skip a few entries, and so you have to go to different pages, and the schedule that we provided was aimed at trying to help navigate that.
Thank you. Can we assume that this text at the top of 26 was set after the decision that comes immediately length?
I would assume that it does. I can only assume that it does because I do think that in this chain of records, it's the chronology is going upwards rather than downwards. Yes. So that is the text that was sent to a 17-year-old saying, "I'm going to get someone to support you with college."
But what he'd applied for was accommodation because he'd gone to Runnymede asking for accommodation.
Yes, my lady, but all I've said, as I said in my respectful submission, is that you have to read the text as the 17-year-old does. And we say that you've got to look at the text and the communication from a 17-year-old's perspective of what then the local authority did. Because in the subsequent events and then subsequent contacts with the local authority, the discussion was still centred around what's going on with your accommodation. That's the broad submission that I am making, is that this text followed with, here's a social worker who meets me on 3 different occasions, and in each occasion, the discussion is still centred around accommodation. And if I can then take you to those records to show you, this is what BC understood, because as to time running and whether or not he has a good reason for knowledge or not knowledge, it has to be from his perspective at this relevant time.
Could you just remind us what conversations, if any, had there been between Vanessa or another social worker and BC before this?
Vanessa and the social worker had a conversation, I believe it's the 18th of September.
Yes.
And that is on page 34 of the same bundle.
Yes. So
that
slots in on the 18th.
Yes.
On 26th. Thank you.
So then after the 20th, there was a further meeting with BC and Surrey County Council, and that's page 30 of your same bundle. You'll see the date at the bottom of page 29, and then the top of page 30 is the minute of the meeting, and you'll see at paragraph 3 of that record, a discussion was centred around, a part of the discussion was centred around his accommodation, and he says he likes it at Kay's, but he is unable to provide any financial support in that home, and that's why he wanted to work, is to pay his way. He then says, he said he didn't want to return home, he doesn't want to live in the caravan. So that was one of the discussion points that was had between the social worker on that day, which is a different social worker called Jane Stubbs.
Remind me of that reference again, please.
29 is the bottom of the date.
Thank you.
With the social worker Jane Stubbs, and then
she's the support worker, not a social worker.
But she's from the council, basically. And then at the end of that entry, the court will see not working well. He hates his mum. Relationship between them has broken down. So that is the analysis. And then it's about next steps, speaking to Kay's mum to confirm he is able to continue living there and support him to get housing. And then another meeting took place on the 15th of October, which is page 31, so it's over the page. And it's a second entry on the 15th of October. They completed the CV, but there was still a discussion on whether or not he can return home, as they were still not on good terms. Then on the 17th of October, after he was hospitalised overnight, it was the support worker Jane Stubbs who attended the mental health assessment, and that's supplementary bundle 64. The assessment report starts at 57.
Hold on a minute, going a bit too fast.
I apologise.
So we're now going to page 64, are we?
Yes, the main document for 64 starts at 57. This is because he was hospitalised on the 16th of October, and this is the mental health assessment in hospital. and you'll see at 64 the people that would they discuss things with. So the report starts at 57. My lord will just make it in case I have lost
Yes. No, I was just wondering what exactly this document was.
This is an approved mental health practitioner's report because it is, and it is not the local authority's document. I just need to say that. It is a document that is completed when someone is hospitalised under Section 136 of
Yes.
the Mental Health Act. And to consider what then are the next steps, because one of the options is to continue to detain someone under the Mental Health Act, voluntary admission or discharge. And this is the assessment to determine what next steps after he was hospitalised on the 16th of October. And so they consult with other people's views, and at page 64, you'll see that Ms. Stubbs was asked to attend the meeting. And she explained to the mental health professional that she has been working with BC since he became homeless and to support him to find appropriate accommodation. So this, I'm just stepping back for the moment because this is for the purposes of the submission. This is about delay, and this is to look at the perspective from the 17-year-old perspective who clearly has experienced some upheaval in his life. And he didn't know the difference between the various ways in which services and assistance can be got. All he knew in our respectful submission is that there was someone from the council. He didn't know the difference between a social worker or support worker called Jane Stubbs, who was assigned to help him with his accommodation situation. And in our respectful submission, at that stage, it was impossible for a child of his age and his situation to know what exactly Surrey was doing was not to accept a Section 20 duty.
Jane Stubbs?
Yes.
Am I right that she is part of the early help team?
The targeted youth
yes,
support team.
Because she's called EHM.
That's
which
correct.
I'm guessing is early help something.
Probably, yes.
Okay, so she's in the team to whom he's been assigned following the decision on the 18th or whenever it was.
Yes, so he's been assigned someone from the council that he knows. You're right that technically, and objectively, she is part of the early help team. She is with the targeted youth support. My submission is here we're talking about what did this child know at the time in 2019. He knew that someone from the council has been allocated to him to help him with accommodation. So that is what he knew.
So what we're looking at 64 is this person, JS,
Yes.
talking to the other social worker, the mental health.
No, talking to the mental health professional, yes.
That's what I mean, yes. It would be a social worker, wouldn't it?
It could
Anyway, never mind. It's the person who wrote this document.
Yes.
The AMPH report.
Yes.
What
Saying, I
she
have
says.
been helping this boy with, because since he became homeless, I have been helping him with accommodation. And for the purposes of the delay question, it's what was the perception from a 17-year-old's perspective.
The judge doesn't make any findings in relation to this period at all.
The judge says he didn't, the judge makes the finding that he did not know that Surrey had acted unlawfully.
Yes.
And so this is the factual background that was set out in Ms. Porter's witness
But
statement.
why do we need to know about that? I mean, the judge found that. The judge found he didn't know.
Yes, so what I'm trying to take you to is the reasons the judge says the delay was justified, because that's the question that the judge had to consider in the round to decide whether or not an extension of time is necessary.
How does the conversation between JS and the other professional help us know what was in BC's mind?
Well, my submission is that BC's impression is that there is someone from the council helping him with accommodation. That is perhaps a very short point that I could have made much shorter, but that is the essential point. And and it's clear that by the time he sees solicitors, my lord, that he also didn't understand the difference
But that's many years on.
No, that's a year and a half on.
Okay. 18 months on.
Yes. So when he
With
went...
a 3-month time limit.
Yes, where we're considering what the judge considered in deciding whether to extend time. So he considers the maximum period of delay, and he had to consider...
Well, that's your submission.
Yes, well, I mean...
And he then picks up the detail
Yes.
from July 2021.
Yes, he does. He does pick up the details because he sees the solicitors in August 2021, and you've seen the letter before claim that was sent and the submissions that have been made by my learned friend on that. But the point that I want to make about that is that when you're taken to the letter at 112 of the same bundle...
Is this the pre-action protocol?
It is.
Yeah.
So this letter, Ms. Rowlands had made a point that the solicitors were writing to Runnymede Social Services, but you'll see at the top of that page on the left-hand corner, the email address that was sent was very clearly to Surrey County Council.
Well, I mean, that's clarified anyway, because there's an email
Yes,
exchange afterwards,
exactly.
isn't there, where law stops say, yes, we sent it to Runnymede by mistake. It should always have been Surrey County Council. So that seems to be cleared up.
That's fine, but 113 to 114 is the sum total of the information that this BC had and was able to provide to the solicitors. Because, and you can see at paragraph at 114, at the top of 114, that he instructs that he was in discussions with social services about sorting out his housing, but he was not contacted after that. So his situation was that he didn't really understand that, our submission is that he didn't really actually even understand at that point what decision was actually made about him. And the solicitor...
Well, of course, you could rely on the first sentence is that he was in care of Runnymede Social Services.
Well, that's the assertion.
When he was never in care at all. And as a matter of... it wasn't Runnymede weren't the relevant authority.
Well, the solicitors could only do the best they can with the pre-action letter based on what information they could piece together from the instructions that BC had given them. And on that basis...
He told them he was a care leaver and he wasn't.
Well, that is the based on the instructions, which is what a pre-action protocol does, and then you get a response
I
from
repeat the question.
protocol.
He told them he was a care leaver and he wasn't.
Well, I think he didn't tell them that he was a care leaver. He told them the information, and the solicitors advised him that he was a care leaver.
Yes, but of course,
That's
if
slightly
solicitors
different.
made if solicitors made a mistake, as we know, that doesn't justify an extension of time.
Not suggesting that it does, my lord.
Okay.
I haven't made that submission that it does. I'm taking you to this because this is relevant context for what then happened and the actions and whether or not those actions actually justify the exercise of the discretion, because that is what the judge had to consider.
Yeah.
So it's focusing on what the judge had to consider. This is what the judge had to consider. And then the judge also considered the pre-action protocol response, which is on the 23rd of August. And that's 122. And the long and short of it, because you have looked at it, the short point is
I'm sorry, page number again, my fault.
122.
So sorry to
I will
behind.
speak slower. I
No, I know
apologise.
you're
I'm
actually
just
fast
very
and I'm not.
conscious of time and
Sorry.
I'm rushing. I apologise.
No.
Pre-action response is on the 23rd of August at 122. You've already looked at it, but the long and short of it is a complete denial that anything that they had done could constitute accepting any duty under Section 20. But they also, as you
Which
see,
remains their case.
I appreciate that remains their case. That, but at 123, they also said, I will not provide any disclosure of the underlying factual chronology relied on for the defence. And in our respectful
Where was
submission,
that? Sorry, where's the refusal?
it's 123. It says,
Yeah.
go make a subject access request.
Where's it? I just haven't highlighted that bit.
It's
Response to the
details of any information sought at 124, my lord.
I see.
My lady, apologise.
Yes, thank you.
So, in our respectful submission, in those at that time, any judicial review claim would have been, at best, extremely speculative, because of the to and fro between the council and the local and law staff, based on only BC's fragmented understanding of what may or may not have happened at the time.
But he knew they hadn't provided him with accommodation.
Yes, but the
He
function.
always knew that.
But the function of the pre-action protocol, my lord, I am seeking to make the submission as to matters that were entirely within, in our submission, within the judge's consideration, taking it all in the round. The question for this court is whether or not that was an error.
Yeah.
And I have to show you what it is that the judge considered first in order to assist the court on whether it was an error.
So where does the judge refer to the response of whatever the
It's
statement?
all set out, it's summarised at 9 to 65 of Claire Porter's witness statement at 101 at the last line. He's deemed to have read that statement. There's often case law to say you don't set out every single detail of everything, but he did read that statement and he cited the paragraphs that he says was relevant at 9 to 65. And we say that on that basis, the function of a pre-action protocol, a protocol is to either flush out the issues, decide whether or not there actually are merits to go for a judicial review claim at the time, and before rushing to court. That's why you have a protocol in advance of rushing to court. And on that basis, we say in this case, on these facts, it was open to, the solicitors were right to embark on efforts to obtain records, and it was open to the judge. It was not an error of the judge to take all of this into account as part of the reason for not bringing the claim right there and then in August 2021. The judge then goes on to decide that it was the knowledge had crystallized, and you can see paragraph 102 of the judgment, the knowledge had crystallized at February 2022. That was when some disclosure was received, and I would just simply say that it was partial disclosure at that point, but he nevertheless took the view that that was sufficient. So with respect to ground 2, the complaint that the judge said you need full disclosure in order for time to run or for knowledge to crystallize, that is not actually correct. What he took the view was that there was sufficient disclosure to take a view to launch a public law challenge on public law grounds against Surrey County Council. So that's the point that he makes that decision. And then what happened is also in Claire Porter's witness statement is setting out what the solicitors did was on the 27th of April 2022, after reviewing this partial disclosure, and that letter is page 141.
Door bundle.
A supplementary bundle still.
Sorry.
So at 141 on the 27th of April, based on the documents that they did receive, they set out, you will see at 143, what they now understand to be the chronology of events that happened, and that runs to 143 to 145, culminating in an assertion at 145 on the basis of the review of documents that there is a public law error in the Surrey's approach. And then at 145 to 146, the solicitors then put various alternative cases as to where the error arose. The final one, my lords and my lady, is at the last paragraph at 146, just above next steps, is that in any event they should exercise, that heading. Alternatively, the local authority acting unlawfully should agree to treat BC as a former relevant child. That's the exercise of the discretion. So that was the first request for it, on the basis that they couldn't have done it with any credibility previously, because they couldn't show that there could be an injustice that needed a discretion to remedy. And that is a response came from Surrey on the 12th of May 2000.
So just pausing there,
Yes.
the judge found that there was sufficient disclosure to bring a public law challenge in February.
Yes.
Here's a letter making the claim on the 27th of April
Yes.
with the various alternatives which you've drawn our attention to,
Yes.
I think reflected, if I remember it rightly, in the statement of facts and grounds
Yes.
when that served. So the question that then occurs is, well, assuming that there was an entitlement to an extension of time up until now, that's to say 27th of April, how could there be a further entitlement?
Well, the 12th of May, response includes.
That's the response. We'll come to
But
that.
that is my answer, my lord.
But
If I
that
could,
can't be right.
it can if
in
it
the
is
law.
about discretion.
No.
It is about
The law is that the not knowing about the claim may be a good reason. The courts have accepted if there was a good reason for the delay, if the applicant was unaware of the decision, provided that they applied expeditiously once they became aware of it. We've still got the 3-month period. There's still an obligation to act promptly.
I don't disagree with your lordship. I'm not quarrelling with your lordship on that. I am simply trying to make my submission as to the chronology of events that the judge took into account when he decided whether it was something that should trouble him, and whether or not then this court decides that that is an error of law or not.
So you're not going to answer my question.
I am going to answer a question, because the 12th of May decision was a relevant decision. I know your lordship may not like the answer.
Well, it's not a
but
question
the
of liking the
No,
answer.
but the 12th of May, they asked for a discretion to be exercised on the 27th of April. That is a request that is separate from you were in breach previously and all along. That is the GE Eritrea discretion. So I have now realised that what you have done to me was wrong. I would like to come to you and ask you to exercise a discretion to treat me as if I was always in the local authority's accommodation, and therefore now have a duty owed under section 23C. That is a separate question to you did everything wrong and you should have always treated me as that, and I want a declaration to that effect. There are two distinct requests that are being made, and I think that is important, because the only way you can make a discretion request is if you actually can demonstrate that an injustice has actually occurred. And they were able to do that on the 27th of April because they were able to make a request with credibility that there should be an exercise of discretion.
So we come to the 12th of May.
Come to top of May, and then there was pre-action correspondence relating to the refusal to exercise of discretion, and then the claim was issued in August 2022. I appreciate my Lord Justice Coulson is troubled by the gap between April and August 2022. My respectful submission is the reason being unexplained or not unexplained is not so that the only factor that goes to the exercise of discretion under section 33, under the extension of time power. It is obviously a highly relevant factor, but there are other factors that go to that. For example, as my Lady Justice Whipple yesterday noted in the cases that we did look at in L in Nottinghamshire and C in Knowsley, the judge also considered in those cases the prejudice to both parties, the merits of the claim, And all of those are factors that come into the same pot as a part of the balancing exercise. And on that point, in terms of prejudice, I draw your attention to paragraph 104, which is where the judge deals with prejudice.
I think he says that the prejudice is in terms of that there's no retrospective relief, financial or otherwise, that's sought. In other words, as I read it, what he's saying is Surrey County Council aren't being asked to provide anything for the past, and they're only being asked to provide what they should have provided all along. But what he doesn't deal with, unless you can show me somewhere else in the judgment, is the prejudice that we've now heard about, which is the prejudice of
Memories fading.
well, sorry, let me finish. It's the prejudice of dealing with this claim, which is that they just don't have the right people in the right place anymore because it's now got so old that they can't deal with it on its facts.
Well, my lady, the first point I was going to make on prejudice is that Surrey didn't actually advance any evidence in front of the judge, either through Miss Andrews' witness statement or otherwise to suggest that that was the prejudice. So the judge is only helped by what information and evidence was before him, and he rightly considered that no information and evidence of that particular evidence from an actual social worker saying there is prejudice, I'm not able to do this. So
Is that what he means by no retrospective relief, financial or otherwise, is sought?
no, so that is a reference to my lady, Mrs. Justice Black, as she then was.
Yes.
That reference in essay in Kent, because
Yeah.
one of the things that she had considered in that case because
You're right.
of delay.
That's exactly why I was asking you that. You'll appreciate we have. Well, I think we've all looked at those cases overnight.
Of course. So that is what
Yeah, paragraph 81.
he had in mind.
Yes.
Was that, well, you're also not looking at that. I don't have evidence now from the council,
Right.
direct evidence from the council, and also what you're asking for is not for the past but for the future.
Yeah.
So those are 2 points that they considered. And then third point is the judge also proceeded on the contemporaneous records, and both parties argued the case on the contemporaneous records because the contemporaneous records showed what happened or didn't happen. And then in the balance, obviously also relevant is the prejudice to BC, which he considers at the second part of 104. And we say that all of these are factors that it was open to the judge to take all into account, put it into the same pot and do the balancing. It's a difficult balance. It's a fine balance.
Not wrong, you say.
But we say not wrong, and that is the test. And in terms of the complaint that he didn't deal with, the question of discretion on relief.
Just pause there. There are two ways of attacking balance on appeal. One is to say that the judge reached a conclusion which was wrong. In other words, he wrongly weighed all the factors, but
Yes.
he identified the right factors
Yes.
but wrongly weighed them, and I think that's charged against you. But the other is to say he or she didn't put all the right factors into the balance in the first place. Do you say that he got all the right points into the balance?
Well, the points that you identified with my learned friend yesterday was chaotic lifestyle, prejudice, and then time and explanation.
Everything that was put to him.
Everything that was put
There
in.
could have been budgetary points put to him, but they weren't. Is that your
That's
point?
those are absolutely relevant points. But in our respect for submission, those are points that he took head on and he addressed. In terms of chaotic lifestyle, my lady, his only reference to that is at paragraph 100 to say, well, that's why he didn't know at the time. That's the extent of that. And then finally, I was going to go on to the discretion on relief, which doesn't actually form part of grounds 1 or 2, but in any event, it was addressed at paragraph 61 of the judge's judgment.
Which paragraph?
61,
61.
page 145.
Sorry, so I read 61. What's that?
So 61.
What does this go to?
This goes to the point my learned friend made about him not considering relief, no discretion, exercising discretion against BC on relief. The argument for the local authority was there's no practical benefit in granting relief. That was the argument for not exercising the discretion. And he deals with that argument at 61. In the second sentence. And
It's
then
quite a sort of unusual place to be dealing with it, isn't it? It's quite in the.
Yes, I mean, I didn't
say.
write the judgment, so all I can point your lordships to and ladyship to is where he deals with matters. It may not be in the most orderly way,
But to be
it
fair
is
to
a finding.
to be fair to the judge, this is the last point in his chronology.
It is, yeah.
Yes, it is.
So he's just dealing with the current position.
Yes, but he's dealing with the submission of Surrey County Council. So he refers to the submission of County Council.
That relief, there was no benefit in any relief.
Yes, but that is the exercise. That is.
But I'm not conscious that that's part of the appeal.
No, I'm not. But Miss Rowlands did raise that as a point yesterday in her submission. So I'm just simply. I might just be.
I'm just
going
dealing
off
with delay at the moment. It can't be relevant to delay.
Yes.
Because that's just whether or not it's in time.
No, this is just my tidy up on the procedural points, and that's a bad structure of my submissions.
Oh, okay. So this is a yes. Well, I think at the moment my understanding, and I'll doubtless be correct if I'm wrong, but my understanding is that you're right to say this doesn't arise on the appeal, under any of the grounds for which permission has been granted.
Yes, I'm grateful for that indication. So I'm just rounding off this point now, which is our submission is not wrong, took account of all relevant considerations. So I was planning now, if I may, to move on to the substantive appeal.
Yep.
Could I make just 2 points to put the appeal in proper context? The first point is that in a case involving an allegation of a breach of statutory duty under the Children Act, there is nothing out of the ordinary for the judge to take an approach to reviewing the document to consider what the public authority did or didn't do in order to determine whether the public authority complied with their duty.
That's what normally happens, isn't it?
That was what normally
That's
happens.
what happened in TW, I think.
It
for
is also
example.
what happened in G and Southwark, which is one case that I know we whizzed through very quickly yesterday, but I'd like to just take you really briefly back to. Because, and that's at tab 17 of the Authorities Bundle, Volume 1, and it's the, sorry, I didn't put my page in there. 333, thank you. So my lord and my lady, this is a case concerning a 17-year-old child. G is 17. And then can I just take you firstly to paragraph 3 of Lady Hale's judgment at 335 and ask you to read paragraph 3.
We've read that. I've got it
Yes.
marked
So-
up already.
So the point is that, notwithstanding the fact that someone is 17, on the verge of adulthood, it is important to get to that the Parliament has deemed them vulnerable and in need of social services duties that are wider than mere provision of accommodation.
Yeah. The age is important. The fact that he is the age that he was, is an important factor
It's
in determining the local authority's duties.
Well, it is not to the extent of Section 20, because it's different for care and looked after. So accommodation under Section 20 oftentimes is said to be in care, but it's not a care order.
I know.
And so there is a distinction between the two. Accommodation plus the support that a child in that situation might have, because for whatever reason, other children, so in M and Hammersmith and Fulham, at paragraph 6, Lady Hale says, well, most children don't expect to just not get any support once they turn 18. But there's these categories of young people who are unfortunately in a situation where they don't.
Yes. But the age, my point, forgive me interrupting you, the point I think we should bear in mind is the age of the young person is relevant to determine when looking at whether they were, the local authority was right or wrong not to treat them as a looked after child, or as a child in need, and when assessing the local authority's approach under Section 20.
I think it depends on the context of my respectful submission.
But we're not disagreeing, are we?
Yes. No, I don't think we are. But because of that, Lady Hale then says at 24 to 26, my lord and my lady, which is at page 341, at 25 and 24 to 26, she makes 2 points. One is the primacy of the specific duty under Section 20 over the general duty to safeguard welfare of children under Section 17, and that's the first part of 25. And then the second part of 25 is the primacy of the Children Act over the Housing Act. And then at paragraph 27, my lords and my lady, she then considers what is the right question under Section 20. And you can see at the top of the page, considering another case called A.N. Coventry, which is in the High Court, the judge in that case asked the wrong question about whether or not the child requires looking after, but rather the question is, does this child require accommodation from one of the listed reasons? That's just below letter A. And the reason for that is the structure of the statute, which is that Parliament has decided that there are circumstances in which the duty to accommodate arises, and then decided what that duty involves. It's not then for the local authority to decide that because they don't like what the duty involves or do not think it appropriate, they do not accommodate at all. And then it's the paragraph in 28 with the list of questions that you have already seen, the list of series of judgments, and what the House of Lords did there was apply that list and consider that list through the lens of irrationality. Because if you see at little subsection 2, subparagraph 2 of 28, that's an example of the court looking at the relevant documents, which in that case was an assessment, and concluding on the basis of what the local authority knew at the time, that it couldn't be seriously suggested that that child was excluded from home, not excluded from home, in the circumstances he was known to the local authority. Obviously, every case on the lens of irrationality turns on the facts and circumstances of that case, but it's just to illustrate that that is the task that a court in these types of cases is conducting, and we say it's the task that this judge did. The second point of principle is that there's obviously importance of respecting social work judgment. There's nothing controversial about that as a statement as it goes. But evaluative judgment in the context of Section 20, which the terms of which are peremptory, shall provide if the qualifying conditions are met. It's not the same as a wide-ranging social work discretion. And indeed, Lord Justice Ward, in A. Croydon, in the Court of Appeal, that list of questions in G comes from his list, and he deals with this and has this particular point in mind about evaluative judgment versus wide discretion when formulating the thing. And that is at tab 13, my lords and my lady. Page number 253 is the paragraph that I'm going to take you to. Perhaps 38 is where he comments at 252 about the nature of the Section 20 duty at letters F to G of 38. And then at 39, he then draws the distinction between what you're doing in an evaluative judgment type situation and a wide discretion type situation, and then culminating in letter E at the end of 39.
The last sentence
Yes.
is your point.
to the extent that my learned friend relies on TW, my Lord Justice Baker's judgment, irrationality, of
I'm coming to
course.
some trepidation now if you're going to say I was wrong.
No. Irrationality, you're quite right, is a high bar, and that's your paragraph 59.
Well, that's what the judge said, and I agreed with it.
And you agreed with that, and that's correct. But that judgment was on that conclusion that the bar wasn't crossed, was on an analysis of the needs assessment in that case.
Yes.
It didn't set out a principle that it can never be crossed.
No.
And at paragraph 60, my Lord Justice Baker cites A. and Croydon, Lady Hale's judgment, and in particular, that judgment at page 653, paragraph 60.
Well, you're going to my judgment now, are you?
Yes, please. 653 is volume 2.
So we're in TW now.
TW 653.
635.
653.
Unless you wanted to go to 653.
Yeah, paragraph 60. It's volume 2 for my lords.
I took it out to read last night. 653.
So it's just the last 4 lines of the quotation that my Lord Justice Baker sets out in terms of Lady Hale's judgment in A. and Croydon. It's entirely reasonable to assume that Parliament intended for such.
I thought it was Ward. Sorry, I've got in a muddle. I thought Ward, Lord Justice Ward, was A. and Croydon. Didn't we just look at it now?
Yes, he was A.
in the
and
Court
Croydon
of
in
Appeal.
the Court of Appeal.
Then it went to the Supreme. So this is a different aim. This is the appeal.
Same one, but
no, it's not the same case. It's the appeal from the court.
Yes, that's what I meant.
we just
I'm
looked at.
sorry, that's what I meant.
So it goes Croydon at first, Croydon Court of Appeal, then Southwark Supremes House of Lords, and then Croydon House of Lords, okay, in which they reverse the Court of Appeal.
No, so they A. and Croydon House Court of Appeal was upheld in A. and Croydon House of Lords.
Right.
The issue of A. and Croydon in the House of Lords, as my learned friend explained, was: is this person a child?
Okay,
So the
right.
question
Yes, it was. I know that's right.
The age
I remember.
assessment.
Yeah,
I remember.
age
Sorry,
assessment was not about this.
even though I read it last night, I forgot.
But all I'm taking your lordships and your ladyship to is the last 4 sentence at 653, which is that, yes, evaluative questions to be determined by the public authority, but it is still subject to the control of the court on ordinary principles of judicial review. That is not, in our respectful submission, a controversial proposition. And
I don't think that's an issue, is it?
Yes, but the ground 4 is about substituting the views, and so I need to set out what I say is the approach in these types of cases and why the judge got it right. And the reliance by my learned friend on TW in terms of evaluative judgment and not respecting evaluative judgment only goes as far as if there is no public or error. That is just this simple point of principle, because she did take you to the part of TW and DF about the importance of evaluative judgment. But I just want to add the caveat to that.
Well, that's why I read it all last night.
Yes.
Just make sure
That's
I got
my
it.
caveat.
Remember what
We're
I'd said.
focused on the caveat aspect in this appeal.
Yes, I mean, it's interesting that that's what you quote, because she was saying that, Lady Hale was saying that in the context of what the issue was in that case, which was, as it says in 27, whether the person was a child.
Yes, and then obviously the
Not
House of
about
Lords then decided that the child issue is not a judicial review question; it's a fact of precedent fact.
Exactly.
So that was how she distinguishes between the kinds of evaluative judgment which are subject to public law controls and the precedent fact, which is why there's a whole jurisdiction now on fact finding. But that's why there's that distinction in 61 and 60. Could I then just say 2 things about the statutory language of section 20, because we went through that very quickly. And I just want to take you back to section 20, which is tab 1, page 5. of the key issues in this appeal, obviously, is section 21, subsection C, and what the prevented from actually means. And so I just want to focus on the language of the statute first, which is the person who's been caring for him being prevented, whether or not permanent. So it doesn't have to be forever and for whatever reason. So that's the statutory language, and it can be either inability to provide suitable care or inability to provide accommodation, because it's suitable accommodation or care. And just before we leave section 20, you haven't been drawn to section 20, subsection 6, 7 and 11. So 6 is about wishes and feelings of the young person, but 7 deals with parental, the possibility of parental objection, but that's caveated.
Sorry, which subsection?
Subsection 7
Of
20. That's caveated by subsection 11, which is the parental objection doesn't arise in the context of a 16 and 17-year-old. And that perhaps is another point going to my Lord Justice Baker's point about 16, 17, the age is relevant because you're in a different state of maturity in terms of objections, whether the parent's objection should bear on their duty to accommodate. The second point that I want to draw your attention to in relation to prevented for whatever reason. Yes.
I'm conscious of the time.
Yes.
There's a slightly different point on 7.
Okay.
Can we just look at it? So the local authority may not provide accommodation under section 20 if the person with PR is able and willing and objects.
Yes.
But that doesn't apply to a young person of this age.
Yes.
So they can. Local authority there's no bar on it.
So they can't say.
That's all about the interplay between the state not interfering with the parental responsibility, which is the underlying theme of the
That's quite right.
Got it.
But then that's
Doesn't apply here.
That's why your point about age does feed into this as well. So prevented for whatever reason was first considered in terms of what it means in G and Barnett.
Yes.
And that's tab 8 at page 115.
It's Lord Hope, isn't it?
Yes, it's Lord Hope, tab 8, 115, and just for your note, it's in a majority judgment. 3 judges went with it, 2 judges didn't. I just need to flag that.
Lord Nichols is against, amongst others.
And it's page 149 for the court.
Hold on a minute. Let's just get there. G and Barnett.
So 149, so paragraph 99 is just about whether in those, that was a case about single mothers who are homeless, ineligible for mainstream support, asking for the local authority, social services to accommodate not just their children, but them under section 20. And 99, the court said, well, they are in need because they're seriously at risk of no roof over their heads. And then 100, you can see that the court at first blush considered that it was an awkward situation for the prevented from to arise under section 21 subsection C because it was the parents' refusal and the actions of the parents that are creating the homelessness. But at G, you can see that the court at F to G says you have to interpret section 21 subsection C in the light of the duty to safeguard and promote the welfare of children, which is section 17.1, the target duty, and then says whatever reason should be given the widest possible scope in that context. So that is what Lord Hope said, and it was approved by Lady Hale in G. For your reference, it's paragraph 24, page 341.
Is that a different case?
No, that's
G.
the same G that we keep going.
G and Southwark.
G and Southwark.
So we're on.
Sorry, yes,
so
we're on
it's a
G and
different
Barnett.
G. Okay.
So G and Barnett, Lord Hope says what he says at F to G,
Yeah.
and then G and Southwark, Lady Hale considers that interpretation of
Yeah,
preventive
and can
arose.
you give me the paragraph reference?
Paragraph
now?
24,
24. Thank you very much.
page 341.
What Lord Hope says is, so it makes no difference whether the reason is one which the carer has brought about by her own act, or is one which she is resisting to the best of her ability.
So she may really, really want to do something, but the circumstances are such that it's just not possible. And I was going to take you to S in Sutton, because my learner friend did take you to that. But that was a case where ultimately it was just really, really impossible for the family.
So what were the facts in G and Barnet?
So they were a group of single mothers with children, and they were ineligible for mainstream housing. And so therefore they had to go to the local authority. The local authority social services said, I will accommodate your children on their own under Section 20. And they said, no, the Section 20 duty can encompass accommodating everyone.
Yes, I see. So that's the as it were, the refusal. It was the refusal to effectively be separated.
Yes.
Yeah.
In the end, the outcome was you can't use Section 20 for the purposes of accommodating the family together. That was the outcome of the judgment. But for the purposes here, I'm looking at, well, what does it mean to be prevented from? And this is what the House of Law says.
And you're going to try to, aim is to show us that a family bust-up, or whatever it might be, comes within the umbrella of prevent.
For whatever reason, whether or not permanently. And S in Sutton, the case that my learned friend took you to, is at tab 9, paragraph 40, page 175. At paragraph 40, you'll see the sentence that my learned friend took you to is at 5 lines down. Prevention undoubtedly involves an objective test. It is not satisfied if, only the child didn't want to live with someone who's willing. But, so there's always a but sometimes that follows. So circumstances do arise where people are so incompatible that they simply cannot live together.
Yes.
And on the facts of that case,
Clever advocacy to go straight to the but we can't ignore the previous sentence.
no, we can't. And I'm not suggesting that you do, but I'm just saying that you've got to look at the paragraph in the round, which is what we do. But the but is...
But it's important, it's an objective test, isn't it? I mean, so you have to look at the reasonableness of the party's conduct.
On both parties'
Yeah.
conduct, yes. And so you can see in that passage that there are circumstances where objectively people are so incompatible that they just can't, even with the best will in the world. And so in that case, Jay's father was unable to offer her accommodation because of her relationship with his partner. So it wasn't necessarily him that is the problem, it was his partner. And that is part and parcel of the circumstances. So that is just an illustration of preventive from, which my learned friend does rely on that, but this is why it's so wide, the scope is so wide. It can be where one person might want to, the other person in the family home doesn't want to, and the circumstances make it not possible. And then finally, L in Nottinghamshire, which I looked at yesterday at paragraph 41, page 194. That was another example where Elle's mother was prevented from because she was assaulted by her daughter, and that the relationship had broken down. Page 194.
Thank you.
Well, she'd been assaulted by the daughter.
Yes, and here...
I think on any view of the word prevented by, I think you'd say, well...
Well, yes, and here BC punched his mother.
Did he?
Yes. So can I then address you directly?
Can we just look at this?
So she
I'm
said
not
she was
looking at
willing
this
to
before.
have it.
41.
Yes.
So, sorry, Renee.
No, go.
Plain L's mother in this case was prevented because she'd been assaulted by the daughter, so badly broken down she wasn't prepared to continue to accommodate the child, and the child was not prepared to be accommodated by the mother. Not a question of choice, a question of force of events.
Yes. I'm not relying.
I'm just talking out, just thinking. Because obviously we're going to come now to the facts of this case.
I'm not relying on any of these cases as a rule of the tick box criteria that are circumstances for prevented from, but I'm showing you these as illustrations of the implementation of this concept that it is of a wide scope. And obviously your lordships and your ladyship have to look at what the judge thought of the records, and whether or not the judge was wrong or right to say it was irrational for Surrey to come to a different view. On that basis, can I come to ground 3? And I would try to do my best with the headings, although some of the grounds do intersperse with each other. The first complaint in ground 3 is that Surrey says judge erred in finding that the duty arose as soon as SCC was made aware that he applied homeless to Runnymede. But with respect, there's no basis for this complaint because, as I showed your lordships and your ladyship, what the judge found was at paragraph 78 of his judgment that the duty arose on the 18th of September. And that's page 150. And I showed the court yesterday that that conclusion was tracked through from 67, which was he's a child in need. On any view, he's a child in need. So it's language of irrationality. 72, on applying the Wensbury unreasonable test at 68, that he was clearly a child in need without suitable accommodation.
You started at 57.
No, 67. I think we looked at 67 yesterday.
67.
67.
Sorry, I heard it's 50.
67.
Yes.
We looked at 67, and then we looked at 72, and then we looked at 75, and the conclusion was at 78. And so we say ground 3, the suggestion is just not correct on the
So this
basis
is 5 days.
Pardon?
This is 5 days.
Yes, but the complaint on appeal on ground 3 was that as soon as an application for homelessness was
Well,
made,
I agree that ground 3 uses the word immediately,
yes,
but it was through the vehicle of ground 3 that Miss Rowlands made her submissions that they didn't owe a duty at all.
I appreciate that.
So
Yes, I am
I
going
mean,
to
I did
then-
rather wonder during her submissions whether what the word immediately was actually doing, because, as I say, she used ground 3 really as the vehicle for her principal submissions that there wasn't a duty at all.
Yes, well, I mean,
So whether it's the 13th or the 18th of September, the real issue is whether there's a duty at all.
well, yes, but, you know, I have to meet the grounds that are
Well, I understand
raised,
that, but-
as the scope of the permission decision.
Moving targets, advocates,
Well,
advocates, the bane of advocates'
I'm
lives.
planning on addressing you on the 18th of
Yeah,
September, my
fine.
lord.
Well, under which ground? Just so that I know
Well-
for my notes.
I have ascertained that it might be ground 4 because it is part of her
Okay.
proposition that what the judge did in the findings was substitute his views. So
Yeah.
that's how I ascertained what it was.
I understand
and
that.
that's how I'm addressing it.
Speaking entirely for myself, I'm not going to get too worked up about the difference between the 13th and the 18th of September.
I appreciate that. Thank you for that indication. So in order to arrive at the conclusion on the 18th of September, the judge had to look at what happened leading up to that. And the focus of the 18th of September is because that's the date that the social worker made the recommendation to her manager that led to the decision on the 20th.
Yes.
And so the judge then started at paragraph 21 of his judgment to set out the factual circumstances of what did this local authority know. And you have looked already at 21 to 24 yesterday. My learned friend took you to those, so I don't plan to repeat that. All I plan to do is draw your attention to paragraph 24, where, and we have given you the references to the primary material, and I'm just conscious of time, not taking you to each and every one of those. But 24, in January 2018, there was a situation of a concern about family breakdown, although that case was closed. What you weren't taken to is the occasions in 2019 prior to him coming to the attention of local authority, previously being notified on a safeguarding basis, and that's paragraphs 25 and 26. And in particular, paragraph...
We saw the reports. We saw the summary in a report of those incidents.
But can I just take you to a more unredacted version of the report, because there is a part of the report that is redacted that is quite important for your lordships and your ladyship to see, and that's supplementary bundle 17.
17?
17, 17.
Oh, 17.
17.
17.
17.
Quite a lot redacted there.
One,
Quite a lot redacted on 17.
17. There's quite a lot unredacted, but the one bit that's unredacted that's important, as compared to earlier, is that his clothes was being in a van next to the caravan, so he was living out of a van, and it's the having to beg for food. That was left out in the previous record, in the more redacted version at page 13 that you were shown.
This is the 29th of August.
Yes. And then at 16, you were shown under the analysis and you might not have shown under the analysis and recommendation that they escalated, the local authority escalated this, and it's 4 lines down from the heading analysis and recommendation. It would be worrying if concerns raised were substantiated.
Sorry, where are you reading from? Page?
At page 16,
Oh, 16.
under the heading analysis and recommendation,
Yeah.
and 4 lines down.
Yes, just going back to the page 17, is this the most we've got? This is the least redacted. So what we do know, this is an anonymous referral. So that was the information they had.
That was the information they had.
And then they go, and that's the analysis on page 16.
And then they do, it was, so the 29th of August, they decide they need to escalate this on the page 16. But then on the 2nd of September, just to complete the circle, at 18, they close the case without investigating.
Sorry, where are you reading from now?
18,
Yes.
2nd of September. Thank you for the information provided through mail.
Sorry, children won't be taking any further action at this stage.
And that was set out and observed by the judge at paragraph 26.
So the concerns, the conclusion reached by this social worker was that the concerns, that must be the anonymous referral concerns, had not been substantiated.
Well, that is what it says, yes.
Yeah, that's what it says.
Yes. So that was a bank holiday, the 29th of August to the 2nd of September, and the judge works that out at paragraph 26. So over that very short period of time, that's what happened. I'm not making a complaint about that. I'm just showing you that information as part of the context for the judge's then consideration of what happened between the 13th and the 18th of September.
Do we know what had been done
There is no...
over the bank holiday weekend, as you
No, I don't
cleverly
know.
described it?
Well, it's I'm just using the judge's words.
Using the judges.
Um,
On what basis had the local authority concluded that the concerns were not substantiated? Had they spoken to the family or?
The observation of the judge was that it appears to be without any investigation. And obviously there's no, that's all we've got are these records. We were all taking the judge to these records, and there were no records shown to the judge in relation to any outcome of any investigation.
Well,
Should there have been? Probably, but
well,
I
we
am
didn't
not
look.
dealing with the past.
But we don't. If we look at the up on 20, there's quite a lot on page 16, leading to the analysis and recommendation.
Yes. So a phone call was made to the mum on the 29th of August after the referral. The analysis happened to say, we need to investigate this. On the 2nd of September, they closed the case.
Well, they say they're not taking any further action.
I'm not using this to say, therefore, he was homeless. I'm just saying that this is the context. Because the judge then says, well, against all this context, and then what happened on the 13th to the 18th, this is what I think was irrational. But that's all relevant.
NAPE is what?
Multi-agency professional something? I don't know.
So after the inquiry on after the analysis on the 28th, there was then
a phone call.
The mother was happy for a check through MAPE. That must have happened, hasn't it? Because that's what is said at 18.
My Lord, I want to move on to the findings that the judge, if I may, on the basis that I'm not suggesting that there was this particular incident was right or wrong. I'm suggesting that this is the general background picture that the judge considered. And my learned friend yesterday took you 231, which I will take you to very shortly, to say, well, it was only about what happened up to 2018, and then he suddenly made this jump to say that, they knew all about this family and therefore, but that was not something that they were open to do. But that's why it's important to look at 25 and 26 as part of the factual background to the judge's findings. And then on 27, my Lord, the judgment, and back to the judgment, he then sets out the approach to Runnymede as homeless, but then also sets out in the third sentence of that paragraph, a referral from Runnymede to social services on that same day.
Sorry, I think I'm on the wrong page.
I'm on page 136 of the core bundle, judgment paragraph 27.
I'm on page 27. Well,
When it says having previously been a child in need of support, when he says, what was he referring to there?
I think he was referring to early help support earlier.
Some period back in time. Thank you.
And then what he sets out in the quotation is the referral itself, which you have looked at. So I'm not going to take you back to the referral at supplementary bundle 84. But the important last three sentences of that past paragraph is that the housing officer confirmed in the referral that was made with BC's mother's knowledge and consent. And for your reference, you can see the consent that's given by both BC and his mother at page 84 of the supplementary bundle, which you were taken to by my learned friend.
Yep.
And I say this is important on the basis of ground 7, because I'm trying my best to keep to my headings. 7 is erred in giving no weight to the claimant's wishes as he expressed at the relevant time, erred in concluding that making a homeless application to the local authority equated to an immediate need for accommodation. Well, firstly, at 27, he makes the observation that a referral was made by the housing officer to social services, but then you weren't taken to paragraph 28 of the judgment, where the judge sets out Surrey's record and view on that day of the referral. So what he quotes at paragraph 28 is the Surrey's analysis on immediate receipt of the referral on the 13th of September. And the original document is at supplementary bundle 21. So he's setting out there Surrey's view, not his views.
21.
21. And you will see, my Lord Justice Baker, if you're on 21, you'll see at the top of it, details of incident, and then the recommendations onwards. And then you see VS-MO 1309 2019 at 1553. And it's Surrey saying this referral is a level 4 due to him being homeless, have issues with drugs. His mother appears to have abdicated responsibility for him, therefore deemed a vulnerable Southwark judgment. And the judge says at paragraph 29, based on Surrey's submission, that level 4, I think you might ask what level 4 is, and that's set out in the judgment at paragraph 29 is what level 4 is. And then paragraph 30, the judge observes the Southwark judgment is likely to have been G in Southwark Lady Hale's judgment. And it is on this basis of considering this picture at 13 September that the judge then goes on at 31 to say it follows. So it follows from all of that I reject the submission. That's the argument was that Surrey was being made to make a snap judgment that it couldn't make. And you can see what the judge said there. So where the judge observed that the Surrey had a knowledge of this child, that he was being prevented because of a progressive deterioration in his relationship. And then the judge goes on.
I know you're going through the judgment. At this stage, what was happening was a referral.
Yes.
There wasn't an assessment.
No. No. But there was a view taken based on information that the local authority had. You looked yesterday at the prevention of homelessness for 16, 17-year-olds.
What is VSMO? The initials on 21.
I don't know, and that's perhaps something that a learned friend can assist your lordship with. But I'm assuming
that was never dealt with before the
initials of the social worker, or something to that effect.
But isn't this just?
See where it is.
It's VSMO is halfway down page 21 in bold, above the passage, the 3-line passage to which Mr. Liu referred, including the Southwark, the reference to Southwark. But isn't that is just receiving in the referral that you took us to at 84?
Yes.
It's not the assessment.
No, I'm not saying that. But the complaint is that he decided on the 13th of September that he was homeless, that BC was homeless, that the judge decided that. But actually, it's a view that was initially taken on the basis of background information that's known, on the back of the referral. I'm not saying that that is the decision.
No.
I'm saying that that is the observation made by Surrey County Council, knowing this child, knowing his family, knowing the background, says we need to escalate this to level 4 because he appears, at least to us at that point, to be homeless, and appears that mum has abdicated responsibility. That is the situation that's captured. It's not judge's view. He's capturing the local authority's view on that day.
But elevated to level 4. That's not their assessment that he was at level 4, is it?
No,
it is.
No, it's not. And then they then take steps to make inquiries.
Yes.
My point is that what's said against the judge was that the judge made a snap decision that on that day he was homeless, and on that day he prevented inquiries to be made by Surrey. That's paragraph 53 of my learned friend's skeleton argument. And I'm addressing the court on the basis of the case that is against us. And it's part of her case that is part of the run-up to the 18th of September. And I'm about to go to the 18th of September, if I may, because then on the 18th of September, the judge at paragraph 34 notes that inquiries were made by Surrey, and you can see that the conversation was with mother. Mother calls BC a complete twat, tells him that he's moved out, he couldn't get his own way, but more importantly, his father told BC to move out, so it's the father who told BC to move out.
Sorry,
Because-
page number again.
At page 138 of
Sorry.
the judgment,
I'm so sorry.
paragraph
Yes.
34,
Yep. Thank you.
his father told BC to move out because he was violent. The original document for my lady, because of the punching, is page 32 and 33 of the supplementary bundle. And then actually at 33, she also says he smashed things up and went to punch me. So punching the mother.
So where are we looking?
I'm reading his father told BC to move out because he was violent. If we can stay on this document, but the original document is 33 of the supplementary bundle. And that document explains, at paragraph 2 of that document,
Sorry, which page?
33,
33.
says, I moved the girls into separate rooms. That says that he smashed things up, went to punch me. His father told him to move out.
Sorry, I thought you said that he punched her.
Yes, he punched her.
Where's
She
that?
said, quote,
I can't find that, sorry.
that's the second paragraph
Yes.
on the top,
And went to punch me.
and went to punch me. Yes.
Yeah, didn't punch.
Okay. Well, he
you
was
you
like,
say okay. This isn't the first time in this case that you have said something which, when we look at the document, is not borne out by the document.
well, the document
When you
says,
say he went to punch, that's very different from he punched me.
but he went to punch,
Fine.
and the judge explained that he was violent.
Well, he got that from what the father said.
Well, no, he got that from what the mother said. She said he smashed things up, and he went to punch me.
Yes.
And then mother also said his father
Yeah.
told him to move out.
Yeah.
So that is what paragraph 34 was about.
Yes.
But also, in the same document, if you go further down that document to the middle of the document, where it says Miss R said Brandon, BC was selling weed, says she said, I can't put the girls at risk. So these were part
Don't
of...
we have to look? Forgive me for interrupting.
Yes, of course.
I know why you're looking at the judgment and 33 in parallel, but don't we really have to look at the whole of 33? Because it's a complex, ongoing crisis within this family, and what we've got to decide is whether the issue is: was it irrational for the local authority to reach the conclusion that?
Well, no, the issue for you is, was it wrong for the judge to find that it was irrational?
The issue. Okay, for the judge was it irrational?
Yes.
Okay, and the issue, that requires looking at the whole of 33, doesn't it?
Yes, of course, the judge, and my respectful submission, the judge did look at the whole of 33, because he then set out at 34 of the decision, the judgment, other things that were said by the mother about BC. For example, he does set out that she said couldn't put the daughters at risk, that he had chosen not to live at home, he was staying with case mum. So he does, I say, set out the document and what it said in a fair way. And then at 35, my lords and my lady, he then deals with what BC said to the local authority, and you can see that for yourself. And here in the middle of the page of 35, middle of the paragraph in 35, he observed that the social worker didn't probe any further about the apparent availability of the caravan, because in the supplementary bundle 33, the record with the mum, there was no discussion about whether the caravan was immediately available or not, so that wasn't actually asked. And this is the conversation at 35 with BC. And I appreciate that at paragraph 35, the judge refers also to BC's witness statement. But the actual finding of the judge is actually at paragraph 69 of the judgment, which is at page 148. And it was focused on the inquiries, the absence of inquiries that were made by the local authority about the availability or otherwise and suitability or otherwise of the caravan. And you can see that 69, halfway down that passage. And this was a point that my learned friend did take on appeal under ground 6, and my Lord Justice Lewison had said, well, the judge didn't reject the suitability of the caravan, but had dealt with it as a Tameside public law error. And you can see that paragraph 69.
So we skip over, do we, the middle sentence on 69 that says grandparents' caravan was obviously not suitable and SCC couldn't reasonably have concluded that it was at 18th September, because I think what you're saying is the failure that the judge alighted on is the next sentence. And the thing that Lord Justice Lewison had in mind was that there was a Thameside failure to inspect, so nobody really knew the character of this caravan.
Yeah.
So the judge didn't know.
No one knew.
Nobody knew.
The local authority didn't know. The judge didn't know. No one knew. That was no one knew at the relevant time, and the judge also saw that no one knew at the relevant time. That's the point. That's the Tameside error, and the SCC could not reasonably have concluded is a language of irrationality. So it was on this picture, the whole picture, that the judge concluded at 36. He makes one finding at 36 of the judgment that at this stage the relationship had broken down and there was nowhere reliable for BC to live. And part of that, my Lord Justice Baker, if you draw your attention to what BC says to the local authority at 35, which is that he was living with Kay, he couldn't go home, he was living with Kay, but he had to go back to the caravan of his parents for showers and a change of clothes. So it was on a view taken by the judge in the round, in our respectful submission, a view that was open to him to take, that given all that was known taken in the round, it couldn't be said that the relationship had not broken down.
I'm troubled that the judge's summary of paragraph 34 is not a precise and accurate summary of what the note says at 33. We haven't got time to go through this in any detail, but the history on 33 of the note is over a longer period, isn't it? It's all compressed in paragraph 34 of the judgment.
Well, it is compressed.
So, for example, he talks about him moving the sisters into the bedroom, but that was at an earlier stage, if you read 33. It wasn't immediately after this the threatened punch. It was before that.
But I think
I mean, the judge in paragraph 34 reads like a very acute incident which had occurred in September, whereas 33 of the note reads more like a longer period of
But whether it was
conflict within the family.
but whether or not it was a longer period, I mean, if there was a longer period of conflict, and we've seen that in the earlier paragraphs that I showed you, that the judge had in mind that there was a longer period of thing. But the judge had to look at not just the note at 33, and the local authority had to not just look at the note at 33, but look at the note at 33, what BC said, what information they had, what information they didn't have, and say, well, can I conclude, or is the local authority rationally able to conclude X? And so it's not a sort of a forensic, I'm going to take this factor, and then I'm going to give this factor this weight, that factor, give that.
Forgive me, it doesn't have to be. Sorry, I interrupt you. Forgive me. But it does have to be forensic if we're looking at if the judge with the relatively high standards that we have to apply here is considering whether the actions of a local authority in this very complex situation are irrational. The local authority is on the ground. It has the responsibility. The guidance, case law clearly establishes the local authority to evaluate, subject only to public law principles in judicial review, and in assessing irrationality, it is important to be forensic, isn't it?
It is important to be forensic, but what you can get out of that still is that the mother has said, I can't put my girls at risk, so that's another relevant factor that is also part of that note, that he still comes around for showers, that he, this is what the mother said, and the local authority in making an evaluative judgment is not just simply accepting everything at face value, is considering that together with what BC says, together with what they do or don't know about the situation, together with the background. And so you're right that the local authority on the ground has to be careful to consider everything in the round. The question is whether or not the judge, in looking at all of the records, so he wasn't just looking at on the day of the 18th of September on its own in isolation, he's looking at that in the context of everything else, whether or not it was open to him rationally or not, to rightly or wrongly, to, I'm getting my terms mixed up, to say the local authority was irrational. Because he also has to do the best he can on all of the records that he has to take. And on a case like this, it may well be that in front of a different judge or in front of different people, different views will be taken.
You're going to tell me to stay in my lane?
I'm not seeking to be disrespectful at all.
No, of course you're not. You're not.
He's looking at the reasonableness of somebody else's decision. I mean, there is a problem here that he has not looked at the local authority's evidence, which is where you'd normally look to find the respondent's explanation of why it did what it did. And I mean, one of the criticisms I think is that he doesn't look at the local authority's evidence, which Lord Justice Lewison says is okay because you can look at the underlying documents. But I think to my Lord Justice Baker's point, that means if you're going to do that, you've got to be really scrupulous about balance in the way you look at the underlying documents. Well, and that's the concern.
But my lady, I can do no better than advance the case that I advance. Obviously, it's for this court to take a view on the application of the test, whether or not he was wrong to have done that, and whether or not that shouldn't have happened ever.
My point about staying in my lane, remind to myself, which is picking up the point you made, it's not for us to decide if it was irrational, but whether the judge was, our question for us to decide, was the judge wrong to decide that they were irrational?
Yes, and I'm sure this court has come across many situations where you may have made a different decision. You may have taken a different view. That itself, in my respectful submission, doesn't mean that the judge was wrong.
It doesn't. You're right. It doesn't.
And that's not with any disrespect to this court.
No.
I am very conscious of the time.
Well, people keep saying that in this case. As you know, you have to finish at lunchtime so that we can fit in the submissions in reply. So just cut your cloth.
For my part, I think you've covered quite a lot of the material. And even though obviously, when writing our judgments, we'll have to look at all this stuff all over again in the light of your submissions.
Well, I think I probably have covered most of what I wanted to cover on prevented from and ground
Yes,
5. All I would draw your attention to is the decision is at 75 of the judgment, and that decision is, for the purposes of ground 4, is not a decision to substitute his view, but a decision on a finding of irrationality. But you can make what you will about whether or not he was wrong to come to that view. On wishes and feelings, my lords and my lady, he deals with that at paragraph 76. He says that there was no error in, so he rejects the submission that he expressed a wish to live with Kay's mother, therefore there was no wish to be accommodated under section 20. The one document that I do need to take you back to is the prevention of homelessness for 16, 17-year-olds, which you looked at yesterday.
Guidance.
The guidance, yes. And that is in volume 2 for my lords, tab 30 for my lady, and it starts at 657, but I want to take you to 663. Oh, 662, I apologise. 662, you will see if paragraph 3.1, it just emphasises what G and Southwark said, which is it's no different whether or not the duty applies. It applies to all young people, including 17-year-olds approaching 18. But really, my focus for this point is at 669. And it's paragraphs 3.41 to 3.45 and 3.48 to 3.49. And the long and short of that.
Could you read those again? Just shout those out again.
3.41 to 3.45 and then 3.48 to 3.49. And it deals in some detail as to the circumstances in which Children's Services can treat a child as refusing Section 20 so that they could go for alternative accommodation. It sets out quite detailed guidance on explaining what Section 20 is, what the implications of Section 20 is. If you don't have Section 20 and you go to housing...
This all arose tangentially in TW, but we didn't. I don't think we looked at this in TW.
No, probably not. But the point here, the short point here, is that there's detailed guidance on what you should do before satisfying yourself as a local authority that the child does not wish to be accommodated under Section 20. And in our respectful submission, the local authority didn't do that. And indeed, in the case of W in Lincolnshire, there is this there's oftentimes this suggestion that the child doesn't want to be in care and therefore the wishes and feelings are not Section 20. But in care, and the concept of in care from a 16, 17-year-old could mean something very different to what actually legally it means.
Yeah.
And that
People using care to cover voluntary accommodation as well as under a care.
in a very loose way,
Yeah,
yes.
they do.
And that exactly is the observation made by the court in the case of W in Lincolnshire, and that's tab 12, page 228, paragraphs 37 to 38.
Actually, it's an error which it's at least one of your skeletons uses the phrase, I think, globally when not precisely. But, it is a common error.
I refer to this case at paragraph 58 to 60 of my skeleton argument, if I can take that as a shortcut. But the short point is you've got to be quite careful about that. Ground 8, parental objection, I've shown you 20 subsection 6, 7 and 11 as to parental objections not being determinative in the case of a 16, 17-year-olds. And then second point on that is BC's mother knew full well that he was seeking the referral from the housing to social services for accommodation, and she consented to that referral. Yes, there was an offer of targeted youth support, but in our respectful submission, that doesn't take the argument to its fullest because that was accepted because that was what was on offer. you take they need help. They take what help they can get. You look at it from the layperson's point of view as to whether or not they accepted that help as a means to refuse something else.
So that's, in other words, consent is not relevant. The fact that they consented to this, what the parents consented to this, is not relevant to determining rationality. Is that your point?
Yes. I can move on to ground 9. The point at ground 9 is that the judge was wrong to find that a central role was played by the local authority on the 17th of October to accommodate him at Kay's house. The judge's dealing with that is at paragraph 81 of the judgment, and you can see that he sets out firstly a picture where a major role isn't just a sudden single moment in time. He looks at what the judge looked at what the local authority did over a period of time, culminating in an action that he deemed to be decisive. So the picture post 20th of September, I'm not going to take you to every single document. We've given you the references, but and the view obviously will be taken by this court whether or not the judge was forensic or not forensic about the issues. But
why do we start on the 20th? Why don't we, if we're looking at what happened with Kay's family, don't we start before the 20th?
I think we've looked at, the reason why, because the judge decided that on the 18th duty arose, but he wasn't accommodated right there and then. You can see that at paragraph 79 of his judgment, that he rejects our submission that the accommodation happened on the 20th of September. That's why he then at 81 starts with what then happened after the 20th of September.
But where was he living, physically living?
He was at Kay's house on the 20th.
From what date?
From prior to the referral from housing to social services.
Yes, so that was his existing accommodation.
That was it, yeah.
From an earlier date.
That's right. But it's important then because on the 16th when he was hospitalised, what he said to the mental health group, including in the presence of Jane Stubbs, was that he had been kicked out of Kay's house. And you can find that reference, my lord, in paragraph 51, paragraph 50 of the judgment. He makes the finding on the basis of the records that he had been kicked out of his friend's place.
So paragraph 60.
50.
50.
143 is the page number.
So he's there recording the note.
He's there recording.
It's not a finding, it's just he's recording.
No, I'm not saying it is a finding. He's recording the factual situation that BC conveyed to the hospital in a mental health assessment.
Yeah.
Do we know that these are BC's words?
It was summarised it was the words encapsulated by the assessor under the heading BC's views. So I don't know whether or not in quotation, it is a quotation from the records themselves. It's at page 91 and 92 of the supplementary bundle.
And the date of
and
the...
65, actually, it's sorry, my lord, it's in the schedule of references, and it's 91 to 92, that's right.
So it's supplemental bundle, 91 to 92. And is it the 16th of October?
Yes, and then the mental...
So it's not referred to it's referred to by the judge as a document at 50, but not in his summary of events at 81.
Well, at 81...
This is his summary of events this is the judge saying things were very different by the 21st of October compared to the 18th
Yes,
of
so
September.
he deals with the homelessness issue. He doesn't he doesn't recite the quote at 50, but he does then at F deal with the circumstances that led at 17th of October that led to a move, take Jane Stubbs taking him to the house of K, and he sets out that F is at 51 of the judgment, so it refers back to the facts at 51.
Yeah, I'm just a bit confused. On the 16th, he said he'd been kicked out
Yes,
of Kay's house.
yes.
On 17th, he's back there.
Because he was so 16th he was kicked out. He then tries to commit suicide. He was hospitalised under Section 136 of the Mental Health Act, and that's summarised at 49. You see, at 49 leads up to 50.
So you say the 50th, where's that?
49 of the judgment. It says matters came to a head.
Yeah, 16th of October, family friend, member of the family, train station. You said that he was kicked out on the 15th.
No, I didn't say. I said on at page 50, the summary from the hospital was hospital. He told the hospital
Yes.
he had been kicked out.
And I'm just trying to work out, he told the hospital on the 16th that he'd been kicked out.
I don't know the precise date.
Well, it must have been,
It must have been before.
Yes, it
he
must have
tried
been
to kill
before.
himself.
but he told them on the 6th, but on the same day or the following day, he was back at Kay's house.
Because he was discharged from the hospital.
Yes.
And he was taken by social services back to Surrey County Council, back to Case House, and you can see.
Well, that's the argument about whether he was taken with or accompanied. But anyway,
and-
leaving that aside, that's where he went and that's where he lived again.
Yes, and the judge deals with the factual context of that at 52 of the judgment. So Miss Stubbs takes various steps before taking BC to Case House.
Can we just look at the note that formed the basis of 52?
52, yes. The note is at 53.
Because so you know I'm asking that.
No,
I'm looking to
understand.
see, we've just got that note about kicked out in the medical records, but it could be said that there's something that supports that in the second sentence of 53, and I'm just wondering why that. Sorry.
Sorry, you were asking for the records on 52 or 51?
The records that support paragraph 52 of the judgment.
So 52 is the calls to Kay's mother and BC's mother, is that right?
Yes, yes.
Yes,
That's
so-
where you were. I think.
Yes. So I just wanted to make sure that I understand. So
That's where is that in the
so
notes?
the first call is at 52 of the supplementary bundle.
The 52. It's like the P60 on page 45 and P45 on page 60.
I can't remember who M is. Whose mother is she?
She's BC's mother.
BC's mother.
J is the other mother.
Yeah.
So the first call is at 50. So the call is 52. You have one call at 52, and then a second call, which is at the bottom of 52 and goes to 53. Working out the chronology of how these events, these records are presented, it probably is the second entry that happens first, and then the first entry. But either way, those are the two calls that the judge sets out at 52.
Right. So, sorry, the one at the bottom of 52, 53,
That's Kay's mother.
that's K.
And then
The note at 52 describes him, second line of the note as, I had returned him to, that's presumably Kay's mother's home, where he is currently staying.
At 52, my lord, is that what you...
52, the entry call to M at the bottom
Yes.
of the page. Second line, I explained he had now been discharged and I had returned him to,
Yes,
redacted, that must be Kay's
yes.
mother's
So,
home, where he is currently staying.
yes. Well,
No.
currently as in
Currently, I mean,
on
at that
day.
precise moment.
Yes. I'm trying not to over-lawyer the records made by social services, but it would make sense in the context on the 17th of October because that's what happened.
Okay.
Because he wasn't there previously on the day before, but he was there on that day currently.
Well, we don't know that.
Well, we only know
We don't know. We only know what he told the social worker, sorry, the mental health professional
Yes.
on the 16th or 17th.
I can
It's
only...
all chaos. It was no doubt chaos at the time.
It was chaos at the
And
time.
and it's,
And the social worker used the word currently, probably not conscientiously meaning one way or the other. That is just what, as a matter of fact, happened on that day. And she was reporting that to the mother.
Okay. Anyway, you're dealing with ground 9, and you're dealing with the accommodated point.
Yes. So this is the picture that the judge considered. And could I go back to 81? The judgment.
Yeah.
Based on these records, the judge makes a finding at little h at page 152.
well, we start with 81 in the first sentence.
Yes.
So at that stage, the Whipple had not yet played any role in the accommodation of BC at Kay's mother's.
Yes. And then he goes through A, B, C, D, E. All of these refer back to factual paragraphs earlier in the judgment.
Yeah.
And then we then go to F and G, which are the situation on the 17th of October. And then he makes his finding at H.
Yeah.
And he finds that the local authority contacted both mothers, made the arrangements with both mothers' knowledge, and didn't just gift a lift to BC. And we respectfully submit that on the judge's review of the records, that was a decision that was open to him to make.
Yeah.
And he applied the case law principles that in C and Knowsley and A in Coventry about the local authority taking a central role in placing the young person in accommodation, and I cite those at paragraph 67 of my skeleton argument.
And Coventry was the second one. The first one was?
Knowsley, C and Knowsley.
Yeah.
It's paragraph 31 of C and Knowsley, tab 14, page 276, and paragraph 61 to 66 of A in Coventry.
References for Knowsley again?
31, page 276, tab 14. A in Coventry is paragraph 61 to 66, 294 to 295, tab 15.
Thank you.
And we say that the judge's approach was entirely in line with a lawful approach to considering the records and make a lawful, correct decision on the irrationality of the local authority's approach. So I come finally, I hope to very quickly deal with cross-appeal ground 1.
Just before you do, what about the question of suitability?
What do you mean?
My understanding is there's an issue that the judge found, on the one hand, that the local authority had been involved in, had helped to arrange the accommodation at Kay's mother as suitable accommodation, but in fact it wasn't suitable accommodation.
Well, the local authority, it would have been, my respectful submission is the local authority probably took a view that it was the most suitable available accommodation on the very day that it happened. When I come to take you to the case of Imam, which I refer to in the cross appeal context, it's the same thing, which is a duty once arisen may require staged ways of implementing. So in the first instance, when it's emergency and immediate, you might put someone somewhere that is not 100% satisfactory, but it is at least, very least, a roof over the person's head and they are in somewhere safe. And then you might then consider somewhere else. And that's consistent with the statutory guidance that we looked at as well. Because you'll recall in the statutory guidance, it says, well, if someone needs an emergency B&B, pending assessment, that may need to be provided. And we all know that bed and breakfast tends not to be treated as suitable accommodation, even for 16, 17-year-olds, but it is what needs must. It's better than somewhere not safe, because that is consistent with the duty to safeguard and promote the welfare of the child, that imperfection is better than a risk of safeguarding. That's my respectful submission. In the context of social work, the complex picture may sometimes require difficult decisions like that. And we don't criticise it in that context. We say the important issue is when the legal duty bit, and what then happened has to be considered in that context. It's quite understandable also that Surrey didn't properly consider this, because they weren't actually characterising it as Section 20. So they weren't actually, in their minds, having those important obligations in mind. But that doesn't mean, as we've seen from all the cases, that what they did do and didn't do was actually, in fact, in the discharge of the obligation.
So the short point is you say it's not inconsistent.
No.
Yeah. Okay, so then cross appeal 1.
Cross appeal 1 is simply that where the judge...
Let's just identify what we're talking about before, because I've had the grounds open in front of me as a guide. So where do I find in the... Is it in the core bundle?
It's in the core bundle, page 74.
74. Thank you.
So I'm dealing with one, and I'm going to try to deal with it as quickly as I can. In relation to that, our submission, short submission, is once you've identified, so assuming the judge is correct, this has to assume the judge is correct. So assuming the judge is correct on the 18th of September when the duty arose, then he was wrong to find that the duty wasn't performed until the 17th of October 2019. And for that proposition, my lords, my lady, we rely on the case in this court in Re B.
Well, hang on a minute.
Yes, I am hanging on.
Appreciates the administrative court, but before we go to an authority, let's just tease that out as a matter of fact.
Okay.
In this case.
Fine.
Authorities second, facts first. So, wrong to find that the local authority didn't, how do you put it? Didn't perform the duty until 17th of October, right? So what should he have found?
He should have found that by the 18th of September, because the duty had arisen, that what happened then is the local authority allowed for BC to remain at case pending further action.
So BC allowed,
Surrey
allowed BC to stay at Kay's mother, so that effectively the decision effectively the judge's decision about the 21st of October gets rolled back a month, that they were responsible effectively for the accommodation at Kay's mother from the 18th of October.
18th of September.
Sorry, 18th of September, you're quite right. Yeah, I understand that. And that has the effect on this particular chronology of
more than 13 weeks, former relevant child as opposed to qualifying child on the judge's analysis.
More than 13 weeks before he attained his majority.
he became 18.
Became 18. That was pompously put. I'm sorry.
It was. It was. He became 18. Yeah. Okay. Fine. All right. So that's the proposition.
That is the proposition.
Fine. And that's all. Are there any? There are no new facts you need to rely on for that.
There are no new facts.
You rely on all the stuff we've been looking at.
Yes, I'd rely on the finding that the duty arose on the 18th of September. So the finding that was made by the judge at paragraph 78
Yes.
was that a section 20, the qualifying
Yes.
conditions.
The duty arose.
Yes,
But he found it wasn't performed
yes.
until the whatever it is, 21st
So
of October.
he separates out, essentially what he did was separate out duty applies, I can wait a month to perform it,
Yeah.
to put it very colloquially.
Yeah. Fine. Okay.
And obviously we make the submission that that followed through to its natural conclusion,
Yeah.
is that a local authority could simply say, yeah, I've accepted the duty. And then if they don't do anything, that duty can just arise without it accruing, the child accruing any rights. In a circumstance where if the duty arises, bear in mind the person has been identified as in need, a person has been identified as having carers that are prevented from providing her with accommodation or care, and the child has been identified as requiring accommodation. I know this is conceptually difficult when the Surrey is saying, well, none of that happened. But
We're assuming, as you rightly said at the start, we're assuming that the judge was right.
Yes.
That the duty arose on the 18th of September.
Yes. So
all I'm establishing is that there's no new evidence.
there's no new
Fine.
evidence.
So
It's a legal argument.
fine. So let's go to whatever
Maybe.
authority it is.
It's tab 25, volume 2, page 541 is where it starts. Perhaps the easiest way to understand the factual context of this is reading the head note, and then I can essentially, it's obviously a sad, complex case where the child was adopted and then the breakdown in the relationship with the adoptive parents, adoptive father and the child.
Yeah.
And Lincolnshire had, been involved with the child and the adoptive father, but things came to a head on the 11th of February 2019, and he said she can't come back, but the child had been in contact with the birth brother and wanted to go there, and the dispute really in this case was whether the local authority driving her there was just facilitating a private arrangement, and therefore they had discharged all their Section 20 duty, because she then ended up in a different local authority and ended up in a secure accommodation. And there was a dispute between the subsequent local authority, Salford, and Lincolnshire as to who has the responsibility for that. And you can see at 42 of the judgment.
So this is all about. This is one of those disputes. Who pays?
Who's responsible?
Yeah.
The law.
Designated local authority.
Exactly. That is the context, but the Section 20 issue, it hinges
And it's a
on.
badly drafted statute, which caused a lot of problems.
And so, which is the paragraph?
Paragraph 42 is the identification of the issue that was on appeal from Salford, which is, did a Section 20 duty was Lincolnshire, had Lincolnshire assumed it already, such that everything that happened after the 11th of February was actually in pursuance to that duty. And at 46, which is on the same page, my lords and my lady, it was common ground in that case that the records were imperfect and that you couldn't really see exactly what actually went on. But whether it was Section 20 was a matter of, that was decided on the facts. And then the judge goes on at the judgment goes on at 54 to make the findings that it was strongly arguable that by 8th of February, so a few days before the breakdown, that the duty arose. But even if that's wrong, it arose on the day of the 11th when she was excluded from the house. And thereafter, you can see thereafter that at 56, there was an argument, well, she didn't require accommodation because she went missing. That's 56. And then also the arrangements were initially made between the father and the birth brother, DB. And so...
Sorry, who was DB?
Is the birth brother that the private arrangement was said to be for. And Lincolnshire's role was merely to facilitate that move and had never come under the duty to accommodate. And 57, you can see the view of this court is that such an approach would run contrary to the public policy imperative of ensuring that children have somewhere safe to stay and a roof over their head at a time of crisis in their lives. And then finally, my lords and my lady, at 555, 64 and 65 is the findings in that context. And you can see for yourself that the duty arose. It didn't matter that there were difficulties complying with it. They had to do it. Mm-hmm. And the fact that the father called DB in the first instance didn't matter because the local authority remained involved. And we say that this approach reflects also the nature of the kind of mandatory duty that is under Section 20 once the qualifying conditions are met. And it also reflects the Supreme Court's judgment in Imam, which I refer to at paragraph 90 of our skeleton argument. The short point in Imam, which is tab 26, paragraph 38, page 573.
Yeah.
Is that where, in that case, it was a homelessness duty, so they accepted a homelessness duty but didn't perform it. And 38 was clear from the fourth line down, but it is clear that the duty is directed toward achieving an end result, the provision of suitable accommodation, and even if some time is required, we can ultimately this would be achieved, it would be implicit that the end result would have to be achieved within a reasonable time.
So that's different.
Well, can we read on to the rest of that paragraph? Since the end result is intended to satisfy an urgent and important need.
Where are you reading from now, sorry?
It's
would be short.
F.
Yeah.
Thank you. Brilliant.
It should be short. And then reading on, it may be that a local authority has an obligation to proceed in stages by accommodating someone with an urgent need as best as can be achieved at a very short notice, whilst taking somewhat longer to consider how better accommodation, which could be regarded as suitable, can be secured later. And so we say, obviously, in this context, we've got a child in need, prevented from returning home, who is requiring accommodation. The time for allowing compliance is necessarily short and requires urgent moves, and indeed consistent with the statutory guidance, it requires urgent emergency accommodation, even if it's less than perfect. And so we say in this context, applying that finding of Section 20 from the 18th of September, applying the approach taken in C in Knowsley and A in Coventry, that at one point, once a duty arises, what the local authority was doing was allowing the child to remain whilst they take other action. So that's the short point in this context, looking at the structure of the law and Imam.
Does the judge's analysis, which you took us through a few minutes ago, paragraph 81, where he goes through it from A, B, C, D, E, etc., have any bearing on this submission?
So we say that he should have, if he considered those are the actions, we say those actions were in pursuance to a compliance of Section 20, however imperfect it was. That was the argument that we advanced below. That's the argument that we have advanced in the skeleton argument as well, that all the steps he sets out are in pursuance to that.
So performance is irrelevant, really. The question is, when did the duty arise?
Once a duty arises and you take action, that's what REB looked at, the actions of the local authority, and said those actions were Section 20, whether or not you called it that or not. In Imam, it says, well, once that is, you've got to do what you can to meet the end result. You might need to take it in stages. It might not be perfect at the first, but you have to achieve that end result. And when Imam says achieve that end result, it doesn't mean you don't do anything in the middle, and it's the stages point that I rely on as well in that paragraph.
It's quite a slender paragraph for all that reliance, because it's plainly obiter. They didn't even hear submissions. And Lord Sales shies away from agreeing with Lord Justice Lewis that suitable accommodation is to be available from the time when the duty is owed, which is your case.
Well, I put I've made my submission that my case I put as related to REB, and we say that in the Imam context, the Supreme Court did consider this. It's not in conflict with the analysis in REB, and also the context of Imam was really, the issue was, should a mandatory order be made? Because in that case, there was a significant delay in actually complying with the duty over 6 years. And the local authority's point was, it's impossible for us because of resources. And that was the central focus of that judgment. But this was an issue that was raised in that context. And we say that this is supportive of the REB analysis. So those are my submissions, and I want to, if I
Was
may...
REB referred to?
No, it wasn't.
No. Okay.
If I may, I would like to leave 12 minutes for my learned friend, Mr Clark, to deal with the cross appeal.
Yeah, the second ground.
Yes.
Yeah. Sorry to have cut your time down, Mr Clark, but I'm sure it'll be scintillating. Even if it's only
boil it down to its barest essence, my lord. So I was planning to set out my submissions on this ground under 6 headings, and we might find that those are cut down rather in the time available. The 6 headings, and apologies for the speed, do slow me down if you need to, but obviously I'm trying to cut my cloth. The 6 headings were the ground and the relief sought, the judge's decision, how this ground fits with the others, the statutory provisions and comparison of the duties to former relevant children and qualifying young people. That was intended to be taking up my Lord Justice Baker's invitation from yesterday to go through the statute. That may well have to be largely jettisoned, I'm afraid.
Yeah.
Given the time we have available. 5th, 2 authorities on the discretion, GE, Eritrea and HP. And then 6th, drawing together the submissions, applying them to this case, including the appellant's response on this cross appeal. So, in terms of the ground itself and the relief sought, the ground is at 74 of the core bundle again, and it reads, the judge erred in holding that given his decision that the respondent was a qualifying child, the issue as to whether the appellant unlawfully refused to exercise its discretion to treat as a former relevant child did not arise. The issue remained relevant and the judge should have determined it. I should say I'll refer in my submissions to qualifying young person, because although the duties can apply to 16 and 17-year-olds, in fact in BC's case, it was only ever once he turned 18 that
Does
this.
this only arise if you get home on ground 2?
Yes.
Ground 1?
And two.
Does ground 2 only arise if you get home on ground 1?
Well, my lord, the third heading I was going to of my submissions, I was going to deal with the interaction between the grounds. If I might leave
How it
just a moment.
fits is one of your headings.
Yes. That's
Sorry.
number 3.
Sorry.
Apologies. In relation to the relief sought, obviously best to deal with the specifics of that if and when we get to it. But broadly speaking, what is sought on this ground of the cross appeal is merely an order that has the effect of requiring Surrey to consider lawfully the question of whether it should exercise the discretion. I'm not going to ask your lordships and your lady to order that the discretion be exercised in his favour.
So we send that back to Surrey County
To Surrey.
Council to say you have discretion, you need to consider.
In
whether
light
to
of the
exercise it.
findings, because the findings of this court will be relevant to whether or not it should be exercised. Second heading, the judge's decision. This is judgment, paragraph 89, it's page 155 of the full bundle. And the judge says, as I've already explained, the issue only arises if the court answers issues 2 and 3 in the negative. Since I've answered those 2 questions in the affirmative, the issue doesn't arise. And so specifically we've seen the judge found that BC was accommodated under section 20 from the 17th of October, giving him 11 weeks before attaining majority. And that therefore, on turning 18, he didn't become a former relevant child, but did become a qualifying young person. And I think it's fair to note in relation to this kind of appeal that the judge does say that all of this had to be dealt with rather at breakneck speed at the end of the hearing. So it's not perhaps a surprise that things got slightly missed in the detail. In relation to the issues 2 and 3 that he refers to in paragraph 89, we'd have to go back to 62 and 63 of the judgment, which is at page 146 of the core bundle. And so you see there, paragraph 62, he recites grounds 2, 3 and 4 of the claim, and then 63 are the issues. Were the arrangements made pursuant to section 20? Does SEC owe BC leaving care duties? And then should it have exercised the discretion to treat BC as being owed leaving care duties as if he'd been looked after? And really the error addressed in this ground comes from the condensing of the duties to former relevant children and the duties to qualifying young persons into the catch-all leaving care duty. So the judge effectively finds at 89, to which I just took you, he's owed leaving care duties, therefore no issue of discretion. And BC's case on this ground of the cross appeal is that...
Well, hang on a minute. We're just looking at the issues here.
Yes.
The judge, at the start of paragraph 63, suggests that those were the issues agreed by counsel.
Yes, I think there's some element of condensing in those, because if you...
Okay, so what, that's wrong too? Because what you're really saying, he was wrong to say that this issue only arises if the court answers issues 2 and 3 in the negative.
Sorry, my lord.
Paragraph 63 of the judgment, page 146.
Yes. In essence, it's because former relevant child and qualifying young person are condensed into leaving care duties in 3. The question in 4 should perhaps have been more nuanced.
Right.
And
So effectively it's a criticism of the statement of the issue, because if the judge had been right to state the issue in that way, then he was right to do what he did at paragraph 89.
yes,
say it doesn't arise.
I think I have to accept that characterisation.
Yeah.
And the short point, the thrust of the submission is there is a difference between the qualifying young person duties that the judge accepted BC was owed and the former relevant child duties which had the Section 20 duty being performed from the date it arose on the 18th of September, that would have given him 13 weeks former relevant child duties. And so there was still what I describe as a injustice in the gap between what he got on the judge's findings and what he should have got.
Because, to put it bluntly, you get more as a former relevant child.
Yes.
I mean, that's the issue.
Yes.
That's why this matters.
Exactly.
And for longer.
You get more and for longer with a slight caveat. There is one aspect of qualifying young person duties that continues to 25, but yes,
Okay.
more hard-edged duties rather than discretions and for longer.
Okay, so that's how it fits in.
And my lord, that was the judge's decision. How it fits with the others was just to set out the permutation on the substantive grounds. If this court finds that no Section 220 duty ever arose, this ground falls away. Because there's no injustice in them not having performed it. If the court allows the appeal on the cross appeal on ground 1 and finds that he did in fact he was in fact accommodated under Section 20, then this also falls away because it's not necessary. There are two
Then to just pause there.
Apologies.
Is that a question from me? Because he would in that case be a former relevant child.
Precisely.
You know what the duties are.
So there's no discretion.
It's all
He
prescribed.
would just have those actual duties.
Yeah.
And there are two circumstances then where where cross appeal ground 2 remains relevant. The first is if the court maintains the judge's decision, duty on the 18th of September, not performed until 17th of October.
Yeah.
And the other circumstance is that if the court finds duty on the 18th of September, but in fact never performed, which is Surrey's case on ground 9, then we'd be in the position where there was a duty which, had it been performed, he would get former relevant child duties, but in fact he's ended up with nothing, and so there's still a discretion to be exercised. The second point on how the ground fits with the others is in relation to delay. And it's in that this ground is not the discretion. What was ground 4 before the High Court isn't affected by delay in the same way necessarily as the other grounds, because if the court finds that in fact time for challenging the failure to recognise a Section 20 duty ran from September-October 2019 and allows the appeal on the basis that the claim was out of time, the Surrey's decision on the exercise of its discretion doesn't actually happen until much later.
Doesn't happen at all, does it?
Well,
You haven't got a Section 20 hook in that case.
there's a question about whether.
I mean, if you lose on the delay point, so issue 1, so you're out of time to bring this claim. That's the end of it, isn't it? There's no discretion. There's no residual discretion point left, is there?
Well, on my reading, Melody, of GE, there's discussion about how this discretion could lead to authorities being approached to exercise some ombudsman type function over their own previous decisions, which seems to envisage, in my submission, that people might approach them sometime after the fact.
Well, I think where you would be, I think where you might be, I can't for my part at the moment see that there's anything left of this claim. I suppose it might be open to you to say, even though the claim's been knocked out, please, Surrey County Council, would you exercise your discretion in our favour because of all these things? And if they then said no, you could bring a fresh claim. Is that what you mean?
Well, if we're left in a situation where the High Court has found that it was irrational to decide that the duty didn't arise, but this court says relief shouldn't have been granted because there was delay, it seems to me that it's still perfectly open to.
We're not there, because haven't you said that if we get to this point, all we do is send it back to Surrey County Council? It's for them to decide what to do next, and then all the arguments about delay become relevant again to a fresh decision.
Yeah,
it's not part of this JR at all. Is it? Certainly, it's not for now.
It's not any arguments about us delaying in requesting the exercise of the discretion would arise at that stage.
Yes.
Yes.
So it's not nothing we have to decide now.
No, it's only to say that the time.
Hang on, because you've got a discretion claim in these proceedings.
Yes, my lord. And we said
if we for whatever reason, if we concluded that the appeal should be allowed and the claim should fail, that would be it.
If you,
I know it's the administrative court, but the finality in litigation is actually still a rule that covers all civil courts.
So it only arises if you've got a claim, valid claim, which we uphold, surely. So we say there is a not only do you get over the delay point, but you also establish there was a Section 20 duty, which on one of the alternatives gets us into the discretion, and then it's I think it's probably still within the ambit of this case, but I'm not entirely sure about that. But then it's a fresh question to Surrey County Council, isn't it? Will you exercise discretion in our favour? Now you know what the legal landscape looks like.
yes, save that. It's essentially that's essentially the question that was asked in April 2022, and was refused in May 2022, and was then challenged in time from May 2022. BC's legal representative set out the basis on which they said that it was irrational to conclude that Section 20 didn't arise. And it may, if this court found, yes, it was irrational, but relief should have been denied, then that would effectively bear out the position in that request to exercise discretion in April 2022.
But if that was asked in April 2022 and they didn't exercise the discretion that had been asked for, and so it was sought by way of these proceedings,
Yes.
if these proceedings fail, then that's final.
Well, I guess the point I was making is that these proceedings don't necessarily have to fail on all. It may be if your lordships and your lady found that the claim should have failed in terms of the challenge to the 2019 decisions.
I haven't
because
picked
of
up with
delay.
any alternative case that's been the target you've been firing at is the September-October 2019 target.
But then there's a separate. So in the way it was
Not in the judgment, there isn't. The judge doesn't deal with the request in April separately.
Well, the claim, the way that it was put in the grounds of claim.
No. Just my point. I am right to say, aren't I, that the judge does not deal with these as if they were two separate claims.
No, they're separate grounds on the same claim.
Yeah, they're separate grounds on the same claim. The judge dealt with them. You say on this point he was wrong for the reasons that we looked at. I understand that. And then that will either succeed or fail. But all my lady and I are doing is exploring as to how there could be anything left.
I mean, he doesn't give a separate decision on this aspect because he says he doesn't need to, but in light of his other findings. But had he proceeded to deal with this, then he would have dealt with it as it was set out in the claim. Paragraph 4 of the statement of facts and grounds said the failure.
Yes, this is definitely in the claim.
Yes.
I've no problem with that. This was definitely in the claim.
As a separate decision.
Well, it was in the claim, and therefore part of the 2-day trial in front of the judge, and now part of the 2-day hearing in the Court of Appeal.
Yes, but
and the claims will either be successful or not. But at the moment, I can't see how jurisprudentially anything could survive.
Because it would have been, you could find that the judge was wrong to allow the claim to proceed on grounds 1 to 3 because of delay, but not on ground 4, and those were always set as those were always so. Paragraph 4 of the grounds said that there was a continuing breach in relation to failure to treat as a former relevant child.
Yeah.
And then the decision not to exercise the discretion to treat as a former relevant child was the 12th of May 2022. So there were two separate decisions. the judge, and indeed this court, could decide that the claim should be knocked out or relief refused on grounds of delay in relation to the first, but not the second.
Yes, but the judge didn't do that.
Because the judge decided not to deal with the second at all.
Well, because the judge approached delay in a slightly unconventional way, but he certainly didn't deal with delay in two different, the factors that relate to delay for the original claim are X, and the factors that relate to the to the discretion claim are Y.
Well, my lord, I think that's because of the order in which he dealt with it. By the time he got to delay, he'd already said that he didn't need to make a decision on discretion.
I follow that dealing with delay at the end was potentially also unconventional. But anyway, there it is. It's a matter for the judge.
I note the time.
Yeah, okay, so anyway, that's how it fits in.
Yes. I'm going to have to skip the statutory provisions and the comparison of the duties.
But what, the statutory provisions, is this explaining, as it were, how each of them arise?
How they arise and what the difference is between what you get as a former relevant child and a qualifying young person.
Well, give us the references and we can read those ourselves.
Well,
I'm familiar, obviously, with a lot of it, but not all of it.
So
Would it be? Should we get them to a note? A list.
we certainly could
Okay,
do a note.
yeah, if you just, with no argument,
Yes.
no argument, simply the references that identify the different, what you get under these different qualifying provisions.
Yes, my lord. My learned friend has produced a version. We were going to have a look at that, and we can agree a note and provide it to the court.
Okay.
So the broad point that I was going to take from that is former relevant child much higher than qualifying.
Yes. Yeah, we get that.
So then the authorities, very quickly, if I might take, I'll probably be about 10 minutes maximum. I don't know whether.
Okay. Well, if you've got the authorities and the
submissions on the facts of this case.
and then the submissions on the facts of this case. So if we come back at 2,
Yes.
we'll give you a maximum of 15 minutes at 2 to deal with those 2 points. Okay.
Thank you.
Okay. 2 o'clock. Thank you very much.